If you bought property in Texas while you were married, having only your name on the title doesn't always mean it's yours alone. In this video, we'll look at why that can still go wrong. In Texas, the starting rule is simple. Section 3.003 of the Family Code says, if either spouse possesses property during the marriage or when the marriage ends, the law presumes it's community property, and that isn't just theoretical. The Texas Supreme Court has enforced that presumption for decades, including in Tarver v. Tarver in 1965 and again in REJYO in 2024. That community bucket is broad. It usually includes paychecks, bank accounts, the family home, vehicles, retirement contributions, business interests, and even most debts taken on during the marriage. What matters most is when the property was acquired. The paperwork can name only one spouse, but that alone doesn't decide whether it belongs to the community. Texas courts have said that directly for a long time. In Long v. Knox back in 1956, the court recognized that title in one spouse's name did not wipe out a community property claim. Texas does carve out a separate property bucket that usually covers what you owned before marriage, a gift meant for just one spouse, an inheritance, and some personal injury recoveries. And those categories aren't just courtroom shorthand. Section 3.001 of the Texas Family Code is the statute that defines what stays outside the property division. If you want a court to treat something as separate property, you have to prove it with clear and convincing evidence under Section 3.003b of the Texas Family Code. Even if an asset started out separate, that clean line can blur when it's mixed with community money or retitled into both spouses' names. When that happens, Texas courts look for tracing through the records. Cases like McKinley v. McKinley in 1973 and Landry in 2024 show that bank statements and tracing evidence can decide the whole claim. And if you add your spouse to the deed, the law may treat that move as a gift. Cochran v. Cochran in 1975 and in REJYO in 2024 both reinforce that presumption. And even if an asset is community property, Texas does not automatically divide it half and half. Under Section 7.001 of the Family Code, the court makes a division that is just and right, which means 50-50 is only one possibility, not the rule. To decide what's just and right, courts can weigh each spouse's earning power, health, who will care for the children, fault in the breakup, outstanding debts, and the overall balance of the estate. And not every case needs a fight. In an uncontested divorce, spouses can agree on how to divide property, as long as the court reviews that agreement and approves it. The more clearly you label assets early and back that up with clean records, the easier it is to protect separate property and avoid an expensive dispute over who owns what. Your strongest move now is to make a full list of every asset and every debt, then mark what is community and what is separate before you sign any agreement. Before you finalize any divorce paperwork, pull together the records that prove your story. That means deeds, account statements, and anything showing where the property came from. If an asset was a gift or inheritance, gather those records too, along with tracing documents that connect the dots from start to finish. Do that work before you file, not after. It can make the difference between saying something is separate property and being able to prove it. To learn more about Texas community property laws, visit ReadyDivorceService.com and read our complete guide. At Ready Divorce Service, we help Texans prepare for divorce and provide step-by-step guidance through the uncontested divorce process. Divorce simplified, life reclaimed.